Are you buying farmhouse in Sindhudurg in the state of Maharashtra? Decoding the law of the land. Welcome to our comprehensive guide on understanding the rules and regulations for buying, selling, and developing farmhouses and permanent and temporary structures on agricultural land, specifically focusing on the Sindhudurg district in Maharashtra, India. The legal framework governing land in Maharashtra is intricate, especially for agricultural land. Understanding this framework is crucial for anyone considering land transactions or construction. The foundational pillars are the Maharashtra Land Revenue Code, 1966, known as MLRC, which covers land use and conversion, and the Maharashtra Tenancy and Agricultural Lands Act, 1948, or MTALA, which regulates landlord-tenant relationships and land transfers. Sindhudurg district, being a coastal area, has additional regulatory controls, primarily the Coastal Regulation Zone, CRZ notifications. These rules impose strict restrictions on development to protect sensitive coastal ecosystems. Now, let's delve into the rules for buying and selling agricultural land and farmhouses in Sindhudurg. A fundamental rule in Maharashtra is that agricultural land can generally only be purchased by a bona fide farmer or an individual who officially holds farmer status. This can be evidenced by a 7/12 extract or a farmer's certificate or through familial connections. Buyers must conduct meticulous due diligence. Key documents for verification include the 7/12 extract, 6/12 extract, mutation entries, 8A extract, title deed, sales agreement, encumbrance certificate, and various no-objection certificates, NOCs. Agriculturists can sell agricultural land, but typically, the buyer must also be an agriculturist. Sellers should proactively verify the buyer's eligibility or confirm non-agricultural conversion permissions to ensure a smooth, legally compliant transfer. Amendments in 2016 relaxed restrictions on selling agricultural land to non-agriculturists, especially in areas within municipal corporations or special planning authorities. However, the land must be put to specified non-agricultural use within 5 years, or penalties apply. Next, let's explore the regulations for constructing farmhouses on agricultural land. Agricultural land is primarily for farming. A farm building is strictly defined as a structure ancillary to agriculture, such as storage or shelter for tools, or a modest dwelling for the agriculturist. It cannot be a commercial resort without non-agricultural NA conversion. Construction of farm buildings has stringent limits: a maximum plinth area of 150 square meters for residential use, a height limit of 5 meters, and only a ground floor. These limits ensure the structure remains modest and primarily functional for agricultural support. Any use of agricultural land for non-agricultural purposes, like a larger residential farmhouse, requires prior permission from the district collector. This process is called non-agricultural or NA conversion, unless specific exemptions apply for planned development areas. Now, let's consider the regulations for temporary structures on agricultural land. Maharashtra's laws don't have a distinct set of rules for temporary structures. Any structure, if its use deviates from direct agricultural support or exceeds farm building limits, will likely be classified as non-agricultural and require NA conversion. Limited construction is permitted for farming-related uses, provided it has necessary approvals. Permission from the local Gram Panchayat is required for any temporary structure, and an NOC from them is a prerequisite for NA permission. Sindhudurg district has unique geographical and historical factors that introduce additional regulatory complexities. The CRZ notification, 2019, heavily impacts development near the coastline. Strict restrictions, including no development zones, limit construction, especially for recreational farmhouses. Compliance with the approved Coastal Zone Management Plan is essential. Sindhudurg and Ratnagiri districts have unique deemed tenant provisions. If a person has cultivated land uninterruptedly for 12 years, they may be deemed a tenant, impacting ownership and potential sale. Buyers must be aware of such claims. Navigating these complex laws requires a meticulous understanding of Maharashtra's land laws and Sindhudurg's specific regulations. For buyers, ascertain, deemed farmer status and conduct thorough due diligence. For sellers, ensure a clear title and inform non-agriculturist buyers of land utilization timelines. For construction, Differentiate between modest farm buildings and larger farmhouses, ensuring NA conversion if needed. Engaging qualified legal and land revenue experts from the outset is not just advisable, but essential to ensure compliance and successful transactions in this unique coastal district. At Zinoha, we ensure that buyers' legal interests are secure and a thorough diligence for land and its use is undertaken before launch of the product. Zinoha products and offerings are legally vetted with professional diligence by experts purely to ensure no legal entanglement to the buyer. For all your real estate requirements in and around Sindhudurg, you can reach to Zinoha that offers a basket of investment opportunities that are legally vetted and ensure buyer security.